Namaste. Wish you all a very good afternoon. This is Rachna Joshi, and I'm here as an assistant professor in School of Pharmaceutical Sciences, Atmiya University. It's a great honor for me to extend a cordial welcome to all the dignitaries. Who are today's expert, to our today's expert, Ms. Preeti Chudhani, and all the attendees. I would like to welcome you all on behalf of School of Pharmaceutical Sciences, Atmiya University. I welcome you all to this online alumni talk on Research to Revenue Drafting of Patent Application by Ms. Preeti Chudhani. Our prayers may be awkward, our attempts may be feeble, but since the power of the prayer is in the one who hears it and not in the one who says it, our prayers do make difference. So let's we all be a part of this wonderful ritual. Thank you, everyone. Now, I would like to invite our respected and honorable principal, Dr. H.M. Tank, to address this event and for his words of wisdom.
of Honorable Yoripata Swamiji, think of our mentor, Vijaya Yagul Swamiji, Vice Chancellor of the Pro Chancellor of the Atmiya University, Sri Ramchandran, Principal of Engineering, Dr. D.D. Acharya, Deputy Registrar, Ashish Kothari, Dean Transformative Academic, DVR, Principal, Learning Science, Teddy Ladwa, Dean, Faculty of Business and Science, Dr. Kaskiwala. On behalf of Atmiya University, I welcome you all on this particular event of Alumni Talk Revenue Drafting of Patent Application by Dr. Preeti Chothani. So now I request Mitchell Madam to welcome the guest and all the participants and give a brief introduction regarding today's event. Thank you.
Mara.
Thank you so much, sir. Um, I, it's truly an honor to introduce your senior and your college mate for such a beautiful and wonderful event. So I literally feel honored to introduce you, Preeti Didi. Um, at this young age, your biodata is so impressive and it's so motivating for us also. If I say about Miss Preeti Chotani, she is currently a founder and CEO of Shri Datta Law Consultancy, Gandhinagar. She is also a registered Indian patent agent under DPIIT, Government of India. She has about 6 years of experience in the field of patent in renowned pharmaceutical industries like Intas Pharmaceuticals and Kedila Pharmaceuticals. if I say about her IPR related achievements, she has two patent, one for her MPharm work and for her PhD work on her credit. For clients, she has filed more than 60 patents, more than 10 designed application, more than 10 copyright application, and 5 trademark application. She has done her B Farm in our own from our own college, Atmiya Institute of Pharmacy, and she is currently pursuing her PhD from Nirma University. Now I would like to hand over this session to Miss Preeti Chothani ma'am. But before that, I would like to invite Dr. Meetal Manwar for the welcoming words. Then we will start with the session.
Good afternoon and thanks to each and everyone here with us for Alumni Talk on Research to Revenue, Drafting of Patent Application, organized by School of Pharmaceutical Sciences, Faculty of Paramedical Science, Atmiya University. On divine presence of Hari Prasad Swamiji, our President and Mentor, Param Pujya Tyagvallabh Swamiji, I heartily welcome uh, Dr. Tank sir, Dr. G.D. Acharya sir, all the principals, HODs of all departments of Atmiya University. It is my pleasure to welcome our beloved alumni and speaker of today's talk, Preeti Chothani. I also heartily welcome all the participated alumni students, faculties, and the students of Atmiya University. As we know, patent play a seminal role in innovation and tech transfer, a crucial element in a country's development and success in global marketplace. There is a strong correlation with patent grants increasing innovation, technology transfer, and economic growth. When we see the current scenario of countries that filed most international patent applications in 2020, China is on the first position. The second rank is of US and third one is of Japan. In 2020, China led the ranking with total of 68,720 international patent applications filed in that year. The leading 10 countries accounted for almost 89% of all applications filed in 2020. India ranks into the top 50 for the first time with 48th rank among the 131 economy featured in the Global Innovation Index 2020. According to World Intellectual Property Organization, only 13,000 of 1.2 lakh patent applications made in India, while 44,477 of 1.07 lakh patents filed by Indians abroad were approved in year 2020. So there is a need to increase the number of successful approved patent applications filed in India by residents of India. With keeping these thoughts, we are going to organize this alumni talk on drafting of patent application to motivate students and faculties to give their valuable contribution to improve patent filing status of India in global market. Once again, I welcome to all for participating in this event. Thank you.
Thank you very much, Dr. Meetal Manwar. Now we are really looking forward to get the insight and valuable knowledge regarding our topic, research to revenue, drafting of patent application. Um, we have few things expected from our attendees for this seamless webinar experience. All the attendees will be muted during the course of this webinar. So if anyone is having any query or question, will be having a separate question answer session after the completion of the talk. So you can address your question there. One more thing, if in case of any inconveniency or if anyone finds any technical issue, you can let us know in the WhatsApp group. We'll try to resolve it as early as possible if anything happens. Um, Over to you, Preeti ma'am. Thank you so much.
Good afternoon, everyone. With a great honor and pleasure, I would like to thank Dr. Tan sir and all the faculty members for inviting me in this alumni talk. I am the student of batch 2010 to 2013. I have done the B.Pharm from the Atmiya Institute of Pharmacy and also done the M.Pharm under the guidance of the Dr. Tan sir. So based on that, I would like to say that the Atmi University is the great and the best platform to nurture various skills which will help you to build your career. So take the maximum benefit out of this platform. Thank you once again. With that, we'll start our today's presentation. Sharing my screen to you all. My screen is visible to all.
Yes, ma'am, it's visible.
Okay. So let's start. So as Rachna introduced myself Preeti Chodhani. I am the founder and CEO of the State Law Consultancy and also the president of the Gujarat State Intellectual Property Council, WICCI. And today's our topic is the research to revenue, drafting of the patent application. So this is just the formal disclaimer. So this presentation is intended for the education purpose only, and this presentation is not to attempt anybody's not to attempt to increase anybody's intellectual property. So starting with the our flow of the presentation. So today's presentation covers a few topics as mentioned in this slide. Basics about the IP and the IPR, about the patents and the patentability criteria, types of the patent application, patent drafting, including the claim drafting, patent filing, in that how to file, where to file, what to file, and the patent draft procedure, and in the last question and answer. So the topic, so name is that research to revenue. So how we can generate the revenue from the research. So that is also one question. So in that, I can say that if we want to generate the revenue from our research work or from our innovations, so for that intellectual property IP is comes into the market. So by the way of the intellectual property, we can generate a money or a revenue from our research work.
Sorry to disturb, Preeti. Uh,
Yes,
you just speak loudly or use headphone, I think, because your voice is very slow, not clearly audible. Sorry to
okay.
disturb.
Study. Now it's okay, ma'am.
Uh, please check your speaker. I think it's full or
It's on full mode. Let me check once. Now, ma'am.
okay. Okay.
Okay. So back to the our today's webinar. So in that basics about the intellectual property. What is the intellectual property? So in that mainly there are two types of the properties. One is the tangible property and another is the intangible properties. So what do you mean by the tangible property? So tangible property is that property
which is in the physical form and which we can touch or feel that properties. For example, jewelry, land, automobiles, furnitures, etc. So this type of the property, there are the tangible property and which is available into the physical form. So we can touch, buy or sell this type of the property. While the intangible property, which is the property which created from our minds and we cannot touch or feel that properties. For example, ideas or the any creations are there. So these all are comes under the intangible properties. So basically, intellectual property is the intangible property which includes the creation of the human intellect. The creation of the specific certain specific period of. So in that we can say that intellectual property can be into the secure hands by the way of the intellectual property rights. So there are many types of the intellectual property rights like patents, industrial designs, trademark, copyrights, trade secrets, geographical indications, semiconductor integrated circuits layout design, and the plant varieties and the breeder sites. So patents, industrial designs, trademarks, and copyright, these four are widely used to protect the intellectual property. And this for best example for the trade secret is the Coca-Cola. So in the Coca-Cola, the composition or the formula of that Coca-Cola and the process for making that Coca-Cola, that is protected under the trade secret IPR. Then we all know that the Gir Kesar mango and the Darjeeling tea, these all are the specific products which can be obtained from the specific region of the country. So that can be protected by the way of the geographical indications. Then the semiconductor integrated circuit layout designs in case of the engineering, especially in the electronic and communication branch, the any new design or the new circuit is come out, then that can be protected by the way of this IPR. Sorry. Then plant varieties and the breeders, right? So in that any new plant varieties is come out, then that can be protected by this type of the IPR. So main most widely used IPR for the institution as well as for the industrial perspective. So that are patents, design, copyright, and the trademark. So, which type of the IP or intellectual property we can protect by this type of the IPRs? So, for patent, any scientific inventions or the any research work in the field of the pharmacy, chemical, or any engineering field that can be protected by the way of the patents. Then, any article which has a unique design that can be protected by the way of the industrial designs or the design. Then uh, any literary work, any poem or the book, or any musical, dramatical, artistic work, then that can be protected by the way of the copyright. And in the last, the logo, word, or any sign that can be protected by the way of the trademark. So this is the basic, all about the basics of the intellectual property and the intellectual property rights. Now moving forward towards the patent law or the specifically about the what's the patent and how we can deal with the patent. Then starting with the basics about the patent. Patents are an exclusive right, or we can say that the negative rights given by the controller to the inventors, means any researchers, which exclude others from making, selling, using, importing, or offering for sale the invention or the research work for the specific duration of time. So patent is the exclusive right or the negative right which exclude others from any of the activity, making, selling, etc. And that rights is given by the government. Patent office, Indian patent office has give the rights to the inventor or the researchers, and these rights are given for the specific duration of time which is known as the term of patent. So in case of the patents, the 20 years is the specific limited time which are given by the government for their to the inventors for their inventions. So 20 years from the first filing date of the patent application. Now, every research work cannot be patented because some of the part or the whole research may be disclosed or known somewhere. So, to give the patent is given to only those inventions which will fulfill the few criteria. That criteria are known as the patentability criteria. If the invention fulfill all these three criteria, then and then it is eligible to protect under the patent. So one is the novelty, any new things in your invention or in non-obviousness means inventiveness, and third one is the industrial applicability or the usefulness. So little bit more about the patentability criteria. So in that, what do you mean by the novelty? So any invention or any technology which is not disclosed or used in any publication, either in the form of the patent or any articles, either review or research articles, any book in India or elsewhere in the world before the filing date of the application. So in the if to file your application by tomorrow, so each and every aspect of your invention of your research that or each aspects will not be disclosed into any of the literature, either patent or non-patent literature. For example, if you are going more and if you are searching your about in find a few of your invention in any of the patent or any of the articles in the India or other than anywhere in the world, then your invention is not a novel, and that's why you cannot file the patent for that invention. Then second is the non-obviousness or the inventiveness. In that, invention must involve the technical advancement of the compared to the existing technology. If something is existed and if you are come up with the advancement of the technology, or you have a economical significance as compared to the existing technology, or you have both technical advancement as well as the economical significance, then you fulfill the non-obviousness criteria. This is little bit very tricky criteria, and many patent examiners or the controller patent office raise the objections under this criteria raise the objections under this patentability criteria. And third one is the industrial applicability and the usefulness. So invention is capable to make and use into the industry and also beneficial for the society. Now there are various types of the patent application. In that, one is the ordinary patent application, which is further divided into the provisional patent application and the complete patent application. Then patent of addition, divisional patent application, conventional patent application under the PCT applications has uh, with respect to the Indian territory, the ordinary patent application, patent of addition, and divisional patent application is applicable. And this last two, fourth and fifth, conventional patent application and the PCT application are the international application. If Indian applicant wants to file outside the India, then they will choose the any of these two route, fourth and fifth one. Convention application can be filed under the Paris Convention, and PCT application is filed under the WIPO, World Intellectual Property Organization. So starting with the ordinary patent application. So in that, first type is the provisional patent application. So a provisional patent application is useful for those patents which are in the, those inventions which are in the ideation stage. If you have just idea for your research work, then you will go for the provisional application. If you have not worked out on your idea or you have now come up with your completed your the project your or your research work, then the filing of the patent application is the advisable. And now to file the provisional application as early as possible to secure the patent, that is the most advisable thing. So when you come across, you have some idea in your mind, then immediately you file your provision application to secure the priority. If you are not securing your priority, then it secured the person, and then that uh, uh, another person's disclosure become prior art for your applications. So provision application has a benefits like we can preserve our priority date. Then we have 1 year of timeline to carry out whole the experiment for our research work. Provision application cannot publish, examine or grant. So complete filing, complete patent application filing after the provisional application, that is mandatory. Now second is the complete patent application. In that, this can be filed directly if your invention or research work has been completed or you have all the data. Then you file application. Or, you file provision. Then within months from the date of the to the application. For you file your to or better result. So for that you have to follow the application. For example, you have drafted a patent or write a patent in such a manner you have mentioned about your product as well as the process, or about your device and process or the use in one application. Then it in the term of the patent office or in the terms of the patent act, it is the multiple invention in the one application. So there is no unity of invention. So for that, we have to divide that application in the form of the divisional patent application. Now, application can be applicant if mentions the product, process, device, is one patent application. By her, he can his application, division application by the controller or the patent. Then also the applicant has to divide his patent application. Now, divisional patent application also has the priority date same as his main or the mother application. Now, this is all about the basics of patents, types of patents. Then moving forward to the patent drafting section. So, anyone have any doubt or question till this? Okay, so we'll moving forward to this patent drafting section, and at the completion of this presentation, we'll conduct the question answer section. So in the patent drafting, drafting means a writing. In general term, how to write the patent, that is known as the patent drafting. So drafting or the writing of the patent application is the combination of the art and the science, and the patent is the techno-legal document. So drafting of patent is little bit, we can say, crucial or the tough task as compared to the research paper writing, because it contains many sections, and it's a technological document, so it's also includes some legal language also. So as we have earlier discussed that what is the provisional and complete, and based on the research stage of the research, we can file the provisional and the complete specification. If the invention is in the initial stage, then better to go for the provisional application and to secure the priority then, and after the within the 12 months period, complete specification will be filed. Now has a many parts, many sections as described below. One is the title of the invention, name, address, nationality of the applicants, preamble of the invention, field of the invention, background of the invention, objects of the invention, summary of the invention, brief description about the drawings, detailed description of the invention, claims, abstract, and if any drawings are there. So patent application contains all these aspects, all these the parts. So due to that, the drafting of patent is little bit complicated. So coming to the first part is the title. So few things you all have to keep in your mind while you are writing or drafting your patent application. So in case of the title, starting with this title, title should be brief and concise, free from any fancy expressions. Then second, it contains not more than 15 words. So 15 words is the limit for to write up the title. Then the followings are not allowed in the title, like inventor's name, the word patent, the abbreviations like etc. So this type of things and the fancy expressions are not allowed into the title portion. Then second is the preamble. So a preamble for the provisional application and the complete specification are different. The following specification for the provisional specification, the preamble, this is a fixed format or the fixed sentence which we have to write after the title. So the following specification describe the invention, that is for the provisional application, and for the complete application or the complete specification, the following specification particularly describe the invention and the manner in which it is to be performed. Then field of the invention. So here we have to write down about the field or the technology from your invention or the research work is come out. Then this field of the invention is start with this type of the prefix, like the present invention relates to pharmaceutical invention or relates to the mechanical engineering related invention or relates to the robotics. So the sentence that present invention relates to is the fix for every patent drafting, every applications. But after that we have to write down the field or the technology of the invention, and we can also further narrow down the technology also. The main is the pharmaceutical, then coming to the pharmaceutical technologies, then coming to the nanotechnologies. So that in that way we can write over there. Then the background of the invention. So in that we have to write about the prior arts. Now what do you mean by the prior arts? So prior arts are patents or the any articles which disclosed about your invention in the whole or in the parts. So all that prior arts need to be listed here in the background of the invention, and the problem which is solved by the your invention. If and no prior art is available, as your invention is very novel and very inventive, so at that time you are addressing some problem, because no research come out without any problem existing problem. So to solve the problem, invention is build up. So that problem we has to write down over there, and how our invention is solved that problem. Now object of the invention or the advantages of the invention, in that also we have to write down the benefits and advantages of the invention in the term of economical, in the term of in pharmaceuticals, in the term of the patient compliance. So its application as well as its advantages. So for the object of invention also there are fixed format or the fixed prefix are there. The main objective of the present invention is, then you have to write down your objective. Then second is another, if you have more than one objectives, then you have to write down that another objective of the present invention is this, then yet another objective of the present invention is this. Sorry. Now, a summary of the invention. So in that we have to write down the brief description of the your invention, how which field is relates, how which problems you have solved, or main crux of your invention, that you have to write down into the summary of the invention. Now coming to the brief description of the drawings, if any drawings are there, especially in case of the technology related inventions. So we have to write down brief about the nomenclatures and parts. In the Patent Act and the Indian patent system, the drawings with any text are not allowed. So we have to give the nomenclature to that text. Suppose any various parts are there into the one device, and that parts have a specific naming, but we cannot write that name, so we give them nomenclature either in the form of the numeric 1 2 3 4, or in the form of the alphabeticals A B C D, or that, and that ABCD or the numbering that can be reflected in brief into this section. Then detailed description of the invention. So write down all the research work starting from the sketch, from where you have started your research work until the end. Everything, all experimental data, all methodologies, all trials with results, everything you have to write down over this detail of description section. And also you have to give the best method to perform the experiment, best method or best process or best composition in the field of the pharmaceutical, that can be written over here. And the most important part for the patent application, that is the claims. Claims, we can say that it is the heart of the patent application, and it's the boundary of the patent application. The whole the rights, intellectual rights of the patent will defined by these claims only. So it's the heart of patent application, and to drafting or the writing of the claims is the most crucial part, as it decides the boundary. If you have mentioned about your composition, it contains A, B, C, D, and E. So A to E components are there, but that you have write into the description part, but you didn't mention into your claim part. You just mentioned the A, B, and C. So your protection for your patent or your research work is given for A to C only. So drafting of claims are very crucial things. Then last signature and the with the date at the end of the claims. Then abstract. Abstracts would be provided with the title of the invention, and it is brief in nature and contain not more than 150 words. So these are few specification which is given by the Indian patent system. Now drawings do not contain any text except flowchart. If flowcharts are there, then we can add the text into it. Then text in the drawing can be, as I have earlier discussed, that the represent in the form of the nomenclatures like A, B, C, or 1 2 3. Then drawing should be given into the A4 size paper. Name of applicant should be mentioned at the left hand top corner of the drawing sheet. Seat number of has been mentioned on the right hand top corner, like seat 1 of 10, 2 of 10, etc. Then signature of applicant and or the agent, patent agent, on the right hand bottom corner. So these are the few specifications that these are decided for the drawings also. Now coming to the claim drafting, which is most crucial part. So there are total main two types of the claims are there. One is the independent claims and other one is the dependent claim. So independent claims are generally the first claim, which is independent claim and which reflect the whole picture of the invention, which you want what you want to protect in the form of the patent, that everything you have to write in the independent claims. Then dependent claims, it, as name suggests, that it depends on the independent claims. Usually the subsequent and keep it in order, and always the claims are start with the preamble I or V claim. I or V based on the number of applicants. And if there are more than 10 claims, then additional fees should be paid to the patent office. So this is the additional features of the patent office. Now basically claim consists of the three parts. One is the preamble, or we can say that the introductory part or the introductory phase, which we can start with the A or N and the title. Second is the transitional phase or the linking part, which may be comprising of, consisting essentially of, wherein, etc. And third one is the body part. So in this, we have to mention all the essential features which we want to protect them. So all the claims would be supported by the description. If you are writing your claim contains A, B, and C, then A, B, and C all three together and individually describe into your description. So this is the how, as I have mentioned earlier, these three parts are main of the claims. So these three parts are explained of the A or N and the are the preambles. That is the part. So comprising and the wherein, these both are the linking part or the transition phase, which link the preamble and the body part. This both are the transition phase. And this other uh, part is the body part, which contains all the essential features for the dependent and the independent claim. Where to file, what to file, how to file. So to answer those questions, how to file? First question is that. So patent application can be filed via physical mode and the e-filing mode. In the physical mode, we have to submit all the documents or all the forms into hard copy to the patent office. And second one is the e-filing mode. So filing through the online portal is the e-filing mode. So e-filing mode have a few benefits. It is the faster process, and in the same day we will receive our application number with the acknowledgement receipt. And in case of the physical mode, we have to speed post their documents to the patent office. Once they will receive the documents, after that they will give us the acknowledgement receipt. Now, then also fees are as compared to the physical filing. We have to pay the 10% more fee if we are going through the physical mode. So to promote the e-filing and to smoothen the process, Patent Office have given the benefit for the e-filing mode. So applicants or inventors will try to file as maximum as through the e-filing mode. Then where to file? So jurisdiction for the patent filing. So mainly total 4 patent offices are available in India at Mumbai, Kolkata, Chennai and the Delhi. So an applicant can file application at appropriate patent office and the jurisdiction. Now which is appropriate office for that applicant. So that appropriate office or the jurisdiction can be decided based on the resident of applicant. Applicant reside where, based on that patent office will be selected, then place of business, then place from where invention originally originated. So based on that the patent office will be selected. So these are the territorial jurisdiction are given by the patent office. The main 4 patent offices are available and based on that territorial jurisdiction are given. So Mumbai Patent Office mainly cover the state of Maharashtra, Gujarat, Madhya Pradesh, Goa, etc. Then Chennai covers all the South Indian parts. Then New Delhi covers the North Indian parts and the Kolkata, the rest of the India. So for our point of view, as we are residing in the Gujarat, we have to file our patent application to the Mumbai Patent Office. Now, what to file? So, to file the patent application, we have to file some forms. So, some formal requirements are there to file the patent application. Form 1 is there, Form 2 is there, Form 3, 26, 5, 9 and 18. So, these forms are required during the whole the life cycle of the patent application. So form 1 is filed at the starting of the patent application when we are applying for the patent. So that application for the grant of the patents which contains all the details about inventors, applicants, then your title of the invention, then your address, email ID, mobile number, and your declaration as inventors are declared there and their signs and date. So all these basic details are given into the form 1. Then form 2 is the application for the provisional and the complete specification, that is the techno-legal document form 2, which we have to draft and which we have discussed into the patent drafting portion. Then form 3, in that statement and undertaking regarding the foreign filing. So if we have filed in the any foreign country other than India, then that details we have to given in the form of form 3. Then form 26, if you are appointing any patent agent or patent attorney, then this power of authorization is given by the applicant to the patent agent in the form of the form 26. Then form 5, declaration as an inventorship. If any institute or industry is filing a patent as applicant, then all inventors or all research to declare that this our work is protected by this industry or that institution. Then form 9, that is request for the early publication, that is optional. The form 18 and 18A. So form 18 is for the request for examination and for form 18A is for the express examination. Now form 1, 2, 3 and 26 are required at the time of filing of patent application. And if we are filing provisional, then 1, 2, 3 and 26 are enough. And if you are filing a complete application directly or after provisional application, then we have to file form 2 and form 18 with that complete specification. Now form 9 is the optional thing. If applicant wish to file, then he can file. Otherwise, that is not a mandatory thing. Form 9 is required for the early publication. Generally, if we are filing the patent application, then patent application will be published after the 18 months of filing. And if person wants to publish his or her application earlier, then he can request to the patent way of form 9. So extra fees they have to pay with, and will be published within a month. Within a 1 month, application will be published. And form 18 is mandatory for the all the patent application to request the examination. Patent office has a deferred examination system. As we are submitting the research paper, so then they have to examine that things to publish the research paper. But in case of the patent, if you are filed patent application, your application has been published. But if you are not filing a request for examination, then they will not gonna examine your application. So we have to file the request for examination within 48 months, and then only they will examine your patent application. So for examination point of view, there are new feature is come out. This is the express examination that is applicable for the women candidates and any international application, startups. Now for the educational institution, if we are going for with the express examination, then the whole patent granting procedure will faster. So these are the forms. Now these are the fees for the patent office. Application for patent, the form 1, we have to give the 1600 rupees fees for this e-filing mode has fees for the e-filing mode, then 10% additional fees we have to pay. Now there are two categories are given for the patent for the fees category. One is the natural person or the individual, startups, small entities, and any educational institute, either self-finance or the government funded institute. And other one is the larger entity, which includes the any industry or large companies. So for that, the fee structure is different. For the individual and the educational institute, we have to give this portion to the educational institute or the individual. For the then for the request for publication, is optional thing. For that 2500 fees is there. For the normal examination, 4000 fees are there, and for the express examination, 8000 fees, almost double fees are there. But in the express examination, we all the patent granting process will be faster. So this express examination is only applicable to the women candidates, startups, small entities, and the educational institutes, international applications. Now this is the patent grant procedure, how whole patent has been granted. So in that, starting with the filing, first applicant has to file the patent application to the patent office. Then after 18 months, publication will be happen. If any requirement is not, if all the requirements has been fulfilled, then this publication can be expedite by filing the early publication request in the form number 9. Then if you are filing the early publication with extra fees, then the publication will be published within 1 month of such request. Or otherwise, in the all case, patent application will be published into the 18 months. Then next step is the request for examination. That will we have to file within the 48 months or the 4 years from the first filing date. Then after filing of the request for examination, this request for examination can be also replaced by the express examination, as I have discussed, and we receive the examination report within the 6 to 9 months. Whole examination process will take the 6 to 9 months. Then after filing of the request for examination or the request for express examination, issuance of the first examination report that will be issued from the patent office, which contains all the objections or any queries which they will find out, and then we have to answer those objections. Then filing of the response, we have to respond that query, the query revised by the in the examination report. Then grant, if there is no further objections, then patent will be granted. And if further objections are there, then hearing or the oral communication are given. In the hearing, we have to present our whole invention to the controller by the way of the video conference, or the physically we can present that. And after hearing also, if the control is not satisfied, and if still he has a uh, objections, then the patent application will be refused. And if in the hearing controller will be satisfied, then the patent will be granted. Then grant notification is come by the way of the email, and also patent that granted patent will be published again. Then if this opposition are the very rare in case of the educational institute, if someone has the same invention and they have filed patent before your patent application, then they may file the opposition for your patent application. And if that opposition filed before grant, then it's known as a pre-grant opposition, and after grant, then it's known as post-grant opposition. So this is all about the basics of the IP, IPR, patents, and the how we file draft patents. So thank you one and all for attending this session and listening me. It's my gratitude to thank you all once again. Thank you.
Thank you very much, Preeti ma'am, for sharing the precise yet detailed knowledge of patent. Again, thank you so much for the valuable session. We are having the few minute time for the question answer. So if anyone from our attendees is having any query or doubt regarding the content, you can put your question here. You can unmute your mic, or you can write your question in the chat box as well.
Hello.
Um,
Yes, I have one question regarding. Am I audible?
Yeah.
Okay. I have a question regarding herbal formulation. Uh, if it is already in Ayurveda, pharmacopoeia, and we add some new herbal molecules, useful molecules in this formulation, and any other excipients, synthetic excipients, and we formulate in a other route of administration. So it can be patented, such kind of formulation.
So any traditional knowledge related inventions which already known into our traditions that as such that cannot be patented under the Patent Act. But if you have come up with the new process of extraction or like that, then you can go for the process patent. And if you have formulated any composition or any new formula which contains the herbal things and other ingredients which are not known traditionally, then you can apply for the patent application. For that, if you have to search out in the one library which is known as the TKDL, Traditional Knowledge Digital Library, which includes all the traditional or all the herbal molecules in that, which are with their applications also. So once you have go through all this, your molecule, you have search on that database, and if you found that that molecule is not in that database, and if molecule is there but the application is not there, and your process for making it is different or your composition different, and the new application, then we can file a patent.
Okay. Thank you, madam.
just to inform the other attendees that your restriction has been removed. So now you can unmute yourself and ask the question if you have any. You can also write in the chat box as well. Okay, I think there is no more question. So thank you, everyone. We appreciate your being with us today, and we care about your opinion and feedback. So anyone from the attendees and I think I can see many names of our alumni from the in the participants list. So if anyone would like to share the experience or feedback regarding today's session, then you can unmute yourself and you can share here. If anyone is wishing to share the feedback.
Hello. Hello.
Yes, Tahir, you're audible.
Am I audible, ma'am? Yes, good afternoon, all. First of all, it's great to see Tak sir and all the faculty members after a long time. It's been almost 3 years since I've passed the college. So it's great. I hope all are doing good. And it was a great session by Preeti ma'am. And I've learned a lot today. Preeti ma'am, by any chance, you are the daughter of Dr. Bipin Chothani?
Yes, I'm daughter of Dr. Vipin
Actually,
Choudhary.
ma'am, I used to meet him during my sales call, and he has also mentioned about you that you were working in Intas at that time.
Okay, just
So
I have
yeah,
left in December, just last December.
okay, yeah, I used to meet him. He's a great man.
Yeah, thank you.
Thank you, ma'am. It was a great session. I've learned a lot, ma'am. Thank you.
Thank
Okay, thank you, Tahir, and we'll be really
Welcome, ma'am.
pleased to know the feedback and experiences from the rest of the attendees as well. So, for everyone, the feedback link will be soon provided in the chat box, and it will also be shared in your WhatsApp group. Just make a note that your feedback link will be activated 30 minutes after this session. So complete your feedback and submit it on time. It is mandatory to get certificate. Um, Now I would like to invite Dr. Samiksha Patel for the final vote of thanks.
Good afternoon, each and everyone present over here. No duty is more urgent than that of the returning the thanks. I'm absolutely honored to be here for the final word of gratitude. On behalf of all of us, I express my sincere gratitude to Parampuja Tyagvallabh Swami for his support and blessing for providing all the necessary help. I would also like to extend my acknowledgement toward our principal sir, Dr. H.M. Tank, D.D. Vyas sir, and Dr. Ashish Kothari for her support and guidance. Thank you so much to Ms. Preeti Chothani for such a wonderful talk. I'm also very grateful to all my fellow colleagues for their constant cooperation and support. Last but not the least, I express my heartfelt gratitude to all the attending for being so patient and enthusiastic for the session. Thank you so much, everyone. There is one request. Please, every participant, switch on the camera because we want to take one joint screenshot. So I request each and every participant, please start our camera. That's why we can take my pictures for our good memory. I again request all the participants, please start your camera. That's why we can take one photo for our good memory. Okay, thank you so much, everyone. Thanks to all participants, dear our alumni students, faculties, and our beloved speaker, Priti Jothani. We're very much thankful to you for delivering such a nice lecture. I also thank all the guests being present here for our pharmacy event. Once again, I thanks to all the participants, students and faculties. And I also send here the feedback link. So please fill this feedback link to getting the certificate. It is compulsory to get the certificate. Again, thanks to all. So here now we complete today's event. So you can leave now.